Hello everyone, welcome back to our Learning Legal English through Case Laws series. In this video, we will study case law number 39 about the determination of civil transactions due to invalid conditions. Including Part 1, Source of the case law, Part 2, Overview of the case law, Part 3, Content of the case, Part 4, Assessment of the court, Part 5, Rules. This law was approved by the Council of Judges of the Supreme People's Court on August 13, 2020 and announced under Decision Number 276/QDCA dated October 2, 2020 of the Chief Justice of the Supreme People's Court. Part 1. Source of the case law. Cassation Review Decision Number 29/2019/DSGDT dated November 12, 2019 by the Council of Judges of the Supreme People's Court on the case of dispute on housing contracts in Ho Chi Minh City between the plaintiff is Mr. Tran Van C and the defendant is Mr. Nguyen Song H, Ms. Tran TC1 and T Tourism 1 Member Limited Company. Person having related interests and obligations includes 03 people. Part 2. Overview of the case law. Background of the case law. Tenant of the state-owned house, the seller, commits after purchasing transfer price of the state-owned house, the ownership of the house will be transferred to the buyer. The seller received the money and handed over the house to the buyer, but the state failed to transfer the price and recognize ownership of the house. Legal resolution. In this case, the contract of transfer house ownership must be determined as a conditional civil transaction but null and void due to failing to make the conditions of the contract. Key words of the case law. Conditional civil transactions, unfulfilled conditions, invalid transaction. Part 3. Content of the case. In the lawsuit petition dated June 27, 2003 of Mr. Tran Van C and the petitions for inheritance of procedural rights and obligations dated April 26, 2011 by Ms. LUheid T C2, Mr. LeMin S, Mr. LeMin D, Mr. LeMin T2 and in the process of resolving the case, the plaintiff represented by Ms. LUheid T C2. In 1982, the family of Mr. Nguyen Viet L. died in 1985, and Mr. Tran Van C. died in 2011, and his three children comprise Mr. LeMin S., Mr. LeMin D., Mr. LeMin T2 are granted the ground floor in front of house having address at number 182, A Street, B Ward, D District, Ho Chi Minh City by the State Bank of Vietnam. In May 1989, Mr. C rented a part of the house to T Tourist Company branch with an area of 50.85 square meters, located at the corner of 2 frontage at D to open a general service shop. Mrs. C1 at that time with the role as the shop chief, and with her husband, Mr. Nguyen Song H, directly made the business and represented the T Travel Company branch to pay the rent in June 1989 of 2.3 of a tael, 24K gold, and to pay more for the rent from July 1989 to December 1992 is 75.1 of a 24K tael. The first payment on July 10, 1989 is 35.1 of a 24K tael. The second payment is 41.1 of a 24K tael on September 1, 1989. In total, Mr. C received 7.51 of a 24K tael. In December 1989, T Travel Company branch did not do business effectively, so she assigned Ms. C1 to continue doing business and pay rent until the end of February 2002. Since March 2002 up to now, Ms. C1 and Mr. H have remained in this area and have not paid the rent. Part of the house is currently used by Mrs. T1, partly by Mrs. K. During the time of using the house, Ms. C1 and Mr. H made construction and repairs. The valid disputed area calculated under to the valuation record dated January 22, 2014 of VND 1,427,421,900 and request the court to consider judge in accordance with the law at current time. For affiliate contract number 05 signed on May 20, 1989 signed with T Travel Company branch, the plaintiff did not request settlement and withdrawal of the request forcing T Tourism 1 Member LLC to pay 1.4824K tael for rent. Because the parties do not sale purchase house and no longer own a rental relationship, the plaintiff requested the court to cancel the commitment made and signed on July 10, 1989 by Mrs. Tran Van C and Mrs. Tran TC1, forced Ms. C1 and Mr. H to immediately pay the part of the house they live in. Agree to pay Ms. C1, Mr. H the cost of repairing the house is VND 64,105,000. The defendant is Mr. Nguyen Song H, Ms. Tran T C1 presented. In 1989, Mr. H and Mrs. C1 transferred a part of an area about more than 40 square meters at the address number 182 Street A, D District of Tran Van C for 7.5 of 24K taels. Both parties wrote handwritten paper to sell the house. On July 10, 1989, Mr. H and Mrs. C1 gave all this gold to Mrs. C, then gave 5 more 1/10 of taels of 24K gold. The total selling price was 08 taels of 24K gold. The transferable area is located at the corner of 2 frontage 8D. At that time, Mrs. C was renting the house above from the State Bank of Vietnam, so the landlord was not granted, so the two sides only wrote in handwritten notes, could not sign the sale and purchase contract. After that, Mr. H and Mrs. C1 transferred to Ms. Tran T Kim T1 a part of the house with an area of about 16 square meters. The transfer with Mrs. T1 was only agreed verbally. Around 2005, Mr. H, Ms. C1 had business cooperation with Ms. LUient T in the above area. According to the commitment between the parties in handwritten paper dated July 10, 1989, when the state allows Mrs. C to buy the price of the house, Mr. H and Mrs. C1 must pay the price of the transferred area and whether Mr. C is responsible for carrying out the procedures to transfer the ownership of the transferred area to Mr. H and Mrs. C1. At the same time, according to the 2003 land law, Mr. H and Mrs. C1 have used the house and land for more than 25 years, so they must be recognized the land and house use rights, so they request the recognition of the house transfer according to the commitment agreement. July 10, 1989, because this is a conditional civil transaction. The inheritors of Mr. C's rights and obligations have a claim for owing house, which is unfounded because according to the house ownership certificate, Mr. C only owns 167 square meters and the area mentioned above. Mr. C has no basis for ownership, so we do not have right to sue. Mr. H, Mrs. C1 do not accept. Because a dispute arose in 1989 has expired, the case is required to be suspended. Transferring a part of the area to Ms. T1 and the business cooperation with Ms. K does not require settlement. In the process of using Mr. H, Mrs. C1 repaired the house with cost of repair calculated according to the calculation of 64,105,000 VND. In case the court does not recognize the house transfer, it is required to return the paid amount. The defendant is T Travel 1 Number Limited Company represented by Mr. Nguyen Van T3. T Travel 1 Number Limited Liability Company is the owner of the T Travel Company branch. In 1989, the branch's representative was Nguyen S1 working as director. The branch was dissolved in 1990. Mr. S1 did not report about the branch sign an associate contract with Mr. Tran Van C, and branch did not hand over the debt at the time of dissolving, so the company had no basis to settle the request for claim money of Mr. C. The heirs of Mr. C's rights and obligations do not have a request to settle for the affiliate contract number 05 dated May 20, 1989 signed with the branch of Tourism Company T and withdraw the request of demanding 1.48 tael of 24K gold for rent, so T Travel 1 Member Limited Company had no other opinion. At the time of requesting a trial in accordance with the law, Mr. T3 requested to be absent. The person with related rights and obligations is Ms. Tran T Kim T1, presenting. Mrs. T1 transferred from Mrs. C1 a part of the house at 182, a street, B Ward, D District, Ho Chi Minh City having an area about 16 square meters in 1989, with the price of 04 taels of gold. The transfer was paperless. Now, Ms. T1 requires that Mrs. C have responsibility for carrying out procedures for transferring ownership to Mr. H and Ms. C1. The transfer between Ms. T1 and Mr. H, Ms. C1 does not require the court to resolve. At the same time, according to Ms. T1, the area of the disputing parties is the shared use of households in the House 182 Street A, B Ward, D District, Ho Chi Minh City. Mrs. C has no right of ownership, so she don't have right to sue. The person with related rights and obligations is Ms. LUient T presented. On April 1, 2005, Ms. K cooperated with Mrs. C1. Business license under the name of Ms. K stating at 182 Street A, B Ward, D District, Ho Chi Minh City. During the time of cooperating, Ms. K does not know about the legal status of the house. At the present, Mrs. C and Mrs. C1 have a dispute and Ms. K has no opinion and has no request. Regarding the cooperation with Ms. C1, the two parties can resolve by themselves. The person with related rights and obligations is the in-house business management company represented by Ms. Pham Thuy H1. House and Business Management Company sold the house at 182 Street A, B Ward, D District, Ho Chi Minh City in 2001. Before selling, they made a record to check the area used by each household. According to the content of the minutes, the disputing area of the house and land in the disputing party landed at the right of use of the owner, Mr. C, is dead until the state withdraws to expand building line. The fact that Mr. C allows him to stay, lease, or transfer is contrary to the regulations, so House and Management Company disagrees. Request for adjudication is in accordance with law. At first instance civil judgment number 28/DSST dated July 27, 2006, the People's Court of District 3, Ho Chi Minh City decided. Cancellation of commitments on July 10, 1989 between Mrs. C and Mr. H and Mrs. C1, Mr. H, Ms. C1, Ms. T1, Ms. K are responsible for handing over to Mrs. C a part of the ground floor of House 182, a street, Ward B, District D, Ho Chi Minh City with an area of 50.85 square meters. Mr. C pays Mr. H, Mrs. C1. 08 gold received plus 27.49 gold damage plus 64,105,000 dong for repair. Total 35.49 taels of gold and 64,105,000 VND. Both the plaintiff and the defendant have an appeal. In Appellate Civil Judgment Number 188/2007/DSPT dated February 7, 2007, the People's Court of Ho Chi Minh City decided. Modifying a part of the first instance judgment. Recognizing the house sale purchase contract between Mrs. Tran Van C and Mr. Nguyen Song H and Mrs. Tran TC1 according to the commitment letter dated July 10, 1989, Mrs. C is responsible for transferring ownership to Mr. H and Mrs. C1, Mr. H. Mrs. C1 paid Mr. C with price of selling house of 169,432,000 VND, at decision number 138/QDKNG-DTV5 dated November 13, 2007, the Chief Procurator of the Supreme People's Procuracy protests the appellate civil judgment mentioned above. At the Cassation Review Decision No. January 2008/DSGDT dated January 25, 2008, the Civil Court of the Supreme People's Court decided. Cancel the first instance civil judgment number 28/DSST on July 27. 2006 of the People's Court of District 3 and cancellation of the appellate civil judgment number 188/2007/DSPT of February 7, 2007 of the People's Court of Ho Chi Minh City, delivering case files to the District 3 People's Court for trial according to first instance procedures. At the first instance civil judgment No. December 2014/PSST dated April 16, 2014, the People's Court of District 3, Ho Chi Minh City decided. Accept a part of the request of heirs the right and obligations of Mr. Tran Van C. Declaration of commitment on the transfer of the right of using a part of the house at number 182A, B Ward, D District, Ho Chi Minh City, signed on July 10, 1989 between Mrs. Tran Van C and Mrs. Tran TC1 is invalid. Forcing the heirs of Tran Van C's rights and obligations is Ms. LUient T C2, Mr. LUient S, Mr. LUient D, and Mr. LUient T2 to reimburse Mr. Nguyen Song H and Ms. Tran TC1 amount of gold received is 0824K gold amounts equals 276,320,000 VND, forcing the heirs of Tran Van C's rights and obligations is Ms. LUient C2, Mr. LUient S, Mr. LUient D, and Mr. LUment T2 to reimburse Mr. Nguyen Song H and Ms. Tran TC1 house construction and repair costs are 64,105,000 VND, forcing the heirs of Tran Van C's rights and obligations as Mrs. Lud T Min C2, Mr. LUment S, Mr. LUment D, and Mr. LUment T2 to pay C47 of 575,550,950 VND to Mr. Nguyen Song H, Ms. Tran TC1, forcing Mr. Nguyen Song H, Ms. Tran TC1, Ms. Tran T Kim T1, Ms. Luong TK have responsibility for handing over the heirs who are Mrs. Lutimin C2, LUment S, Mr. LUment D, Mr. LUment T2 the area of house and land having address at number 182A, B Ward, D District, Ho Chi Minh City includes area of house and land in the main house comprise floors adapting to planning area is 8.11 square meters plus area of house and land in the building line is 42.74 square meters. The first instance court also decides on the cost of court and the right to appeal of the involved parties. On April 24, 2014, Mr. Nguyen Song H, Ms. Tran TC1, Ms. Tran T Kim T1 filed an appeal. On April 28, 2014, Ms. Latimin C2 had an appeal. At Appellate Civil Judgment Number 1515/2014/DSBT dated December 1, 2014, the People's Court of Ho Chi Minh City decides: do not accept the appeal request of Ms. Lud T Min C2, Ms. Tran TC1, Mr. Nguyen Song H and Ms. Tran T Kim T1, uphold the first instance civil judgment. The Court of Appeal also decides on court costs. After the appellate trial, the defendant is Mr. Nguyen Song H, Ms. Tran TC1 petition to consider through cassation procedure for the Appellate Civil Judgment Number 1515/2014/DSBT dated 01/12/2014 mentioned above. In the appeal decision number 38/KNGDTVC3V2 dated March 21, 2016, the head of the Supreme People's Procuracy in Ho Chi Minh City appeals the Appellate Civil Judgment number 1515/2014/DSBT dated December 1, 2014 of the People's Court of Ho Chi Minh City, request the Committee of Judges of the Superior People's Court in Ho Chi Minh City to conduct cassation review to cancel the above-mentioned Appellate Civil Judgment and First Instance Civil Judgment No December 2014/DSST dated April 16, 2014 of the People's Court of 3 District, Ho Chi Minh City, hand over the case file to the First Instance Court for retrial. In the Cassation Review Decision Number 234/2016/DSGDT dated September 9, 2016, the Judicial Committee of the Superior People's Court in Ho Chi Minh City decided: do not accept the protest number 38/KNGDTVC3V2 dated March 21, 2016 of the head of the Supreme People's Procuracy in Ho Chi Minh City, uphold the Appellate Civil Judgment number 1515/2014/DSBT dated December 1, 2014 of the People's Court of Ho Chi Minh City. On January 21, 2017, Mr. Nguyen Song H, Ms. Tran TC1, Ms. Tran T Kim T1 filed a request for review of cassation procedures for the cassation decision number 234/2016/DSGDT dated September 9, 2016 as above. In the Cassation Review Decision number 56/2019/KNDS dated August 5, 2019, the Chief Justice of the Supreme People's Court appealed against the Cassation Review Decision number 234/2016/DSGDT dated September 9, 2016 of the Committee of Judges of the High People's Court in Ho Chi Minh City, request the Judicial Council of the Supreme People's Court to conduct cassation review for cancelling the Cassation Decision number 234/2016/DSGDT dated September 9, 2016 of the Committee of Judges of the High People's Court in Tan Ho Chi Minh City, cancelling the Appellate Civil Judgment number 1515/2014/DSBT dated December 1, 2014 of the People's Court of Ho Chi Minh City and First Instance Civil Judgment No December 2014/DSST dated April 16, 2014 of the People's Court of District 3, Ho Chi Minh City, hand over the case file to the People's Court of 3 District, Ho Chi Minh City for retrial in accordance with the law. At the cassation review hearing, the representative of the Supreme People's Procuracy agrees with the protest decision of the Chief Justice of the Supreme People's Court. Part 4. Assessment of the Court. 1. Records and evidence of the case shown. On July 10, 1989, Mrs. Tran Van C and Mrs. Tran TC1 signed the declaration and receipt with the content: Mr. C received from Mrs. C 175 1/10 of taels, giving the husband and wife of Mrs. C 1 full rights to use the 45 square meters area at house having address number 182, Street A, B Ward, D District, Ho Chi Minh City. Mrs. C did not claim the house, nor Mrs. C 1 did not claim gold. When the state allows Mr. C to purchase the house price, Mr. H, Mrs. C1 must pay the price of used area and Mrs. C is responsible for carrying out the procedures to transfer the ownership of the transferred area to Mr. H, Mrs. C1. Thus, there is a basis to determine that Mr. C has agreed to sell a part of the house number 182 Street A currently leased from the state to Mrs. C1 if Mrs. C is transferred price by the state, or in other words, the transaction between instrument C and Mrs. C1 are a conditional civil transaction. When the state transfer the price of house, the transaction will take effect. Article 23 of the Ordinance on Civil Contracts in 1991 states, in case the parties agree on an event as a condition of performance or termination of the contract, then when that event occurs, the contract must be performed or terminated. Although the agreed conditions in the contract do not violate the prohibitions of the law, do not violate social morality, but in the part of the house and land of C, the agreement to transfer to Mrs. C1 has an area of 42.74 square meters in the building line. The state fails to transfer price of the house and recognize the ownership of the house, the land use rights of Mrs. C, so most of these conditions do not occur. Therefore, the agreement between Mrs. C and Ms. C1 did not come into effect. The Court of First Instance and Appeal declared null and void. 2. According to Article 21 of the Law on Housing 2005, Point H, Clause 1, Article 10 of the Law on Housing 2014 and Article 256 of the Civil Code 2005, owners and entities have other rights to the property, have the right to reclaim property from the possessor, user, or person is entitled benefits from property whose feature does not have any legal basis. Because the disputed 42.74 square meters area of real estate is landed in the building line, the state fails to transfer prices, recognize house ownership and land use rights for Mr. C, Mrs. C, and the heirs of Mr. C have no right to sue for that portion of housing. The first instance and appellate courts force Mr. H, Ms. C1, Ms. T1 and Ms. K to be responsible for handing over the heirs of Mr. C's procedural rights and obligations of the house and land area on the building line. The state does not recognize house ownership and land use rights are unfounded. Cassation review decision of the Judicial Committee of the Superior People's Court in Ho Chi Minh City does not recognize the errors of the Court of First Instance and the Court of Appeal, thereby cassation review decision do not accept the appeal of the Institute. Head of the Supreme People's Procuracy in Ho Chi Minh City, upholding the appellate judgment is inconsistent with the provisions of Clause 2, Article 345 of the 2015 Civil Procedure Code, due to the above reasons. Part 5. Rules. Pursuant to Clause 2 Article 337, Clause 3 Article 343, Clause 2 Article 345 of the 2015 Civil Procedure Code. 1. Accept the cassation review decision number 56/2019/KNDS dated August 5, 2019 of the Chief Justice of the Supreme People's Court. 2. Cancellation of cassation review decision number 234/2016/DSGDT dated September 9, 2016 of the Committee of Judges of the Superior People's Court in Ho Chi Minh City, and cancellation of the appellate civil judgment number 1515/2014/DSPT dated December 1, 2014 of the People's Court of Ho Chi Minh City and cancellation of the first instance civil judgment No. December 2014/DSST dated April 16, 2014 of the People's Court of 3 District, Ho Chi Minh City of the case dispute on housing contracts between plaintiff Tran Van C, died on April 2, 2011. The heirs of Tran Van C's rights and obligations are Ms. LUheid T C2, Mr. LUheid S, Mr. LUheid D, Mr. LUheid T2 with the defendant Mr. Nguyen Song H, Ms. Tran TC1 and others who have other related interests and obligations. 3. To hand over the file of the case to the People's Court of 3 District, Ho Chi Minh City for retrial according to first instance procedures in accordance with law. Content of the case law. 1. Thus, is there a basis to determine that Mr. C has agreed to sell a part of the house number 182, Street A, currently leased from the state to Mrs. C1, on the condition that when Mrs. C is priced by the state, in other words, the transaction between Mrs. C and Mrs. C1 is a conditional civil transaction. When Mr. C is sold by the state at the house price, the transaction will take effect. Article 23 of the Ordinance on Civil Contracts of 1991 states, where the parties agree on an event as a condition of performance or contract termination. When that event occurs, the contract must be performed or terminate. Although the agreed conditions in the contract do not violate the prohibitions of the law, do not violate social morality, but in the part of the house and land of C, the agreement to transfer to Mrs. C1 has an area of 42.74 square meters in the right-of-way, house. The water price does not change and does not recognize the ownership of the house, the land use rights of Mrs. C, so most of these conditions do not happen. Therefore, the agreement between Mrs. C and Mrs. C1 did not come into effect. The Court of First Instance and Appeal declared null and void.